Usually when we talk about like a medical diagnosis,
Hmm.
there's this expectation of clinical precision.
Mm.
It is engineered to be binary.
Right.
Like you fall off a ladder, you break your arm, the x-ray shows that jagged white line fracturing the radius. And the doctor just points to the film and says, there it is, broken.
It's entirely objective. I mean, the bone is either fractured or it's intact. There's really no debate about the intent of the bone.
Exactly. But then you step into the world of human agreements. You step into the realm of contract law. And suddenly it's like someone has just taken a sledgehammer to that x-ray machine.
Oh, absolutely.
We are no longer looking at clean, illuminated white lines. We're looking at a landscape that is just profoundly murky. It feels like trying to read, I don't know, a dead foreign language written entirely in 6-point fine print.
Yeah, where half the words mean something completely different depending on the context. Contract law is the absolute definition of diagnostic muddy waters. We're taking the single most chaotic, unpredictable substance on Earth, which is human intention, and we are trying to forcefully bind it to a rigid, legally enforceable set of rules.
Which creates a lot of friction.
So much friction. The friction between what people meant to do, what they said they were going to do, and what the law actually demands they do. It just generates an incredible amount of heat.
And navigating that heat is our exact mission today. Welcome to the deep dive. We are taking that murky, microscopic fine print, and we are going to make it click.
We really are.
We have a very specific, high-stakes mission for you today, especially if you're staring down the barrel of a law school final.
We are going to completely demystify the entire life cycle of a contract. We're starting from the very spark of an idea formation, moving right through the messy, real-world reality of performance, and landing squarely in the catastrophic fallout of breach and remedies.
Because the ultimate goal here is equipping you, the listener, with the exact analytical framework you need to utterly crush a law school contracts essay.
Yes, exactly.
But even if you aren't prepping for the bar exam, if you're just a wildly curious person, this deep dive is going to hand you the invisible rulebook that governs literally every single transaction in your daily life.
Because you are entering into legally binding contracts every single day, whether you realize it or not.
Wait, really? Every day?
Oh, yeah. Every time you download a software update or, every time you buy a cup of coffee or park your car in a paid lot, you're triggering centuries of legal doctrine.
That's kind of terrifying. But to build this framework for you, we are pulling from an incredible stack of source material. We're unpacking foundational black-letter law. We're dissecting the classic case briefs that have tortured 1L students for generations.
The absolute classics.
And most importantly, we have our hands on literal insider study notes. The kind passed down from top-tier students, complete with some truly bizarre, but completely unforgettable mnemonics that will save your life when the exam clock is ticking down.
Those study notes are the golden ticket, honestly. Knowing the law is only half the battle. Knowing how to structure your analysis under extreme time pressure is what separates an average grade from the top of the curve.
Okay, so let's start at the absolute beginning. Imagine you're sitting in the exam room. The proctor yells, "Begin," and you flip over the test booklet.
Heart pounding.
Right. You're staring at a massive, complicated fact pattern involving a farmer, a tech CEO, a broken tractor, and 3 different oral promises. Before we even look at a single promise, before we even whisper the word contract, where's the absolute very first place your brain has to go?
You have to identify the gateway issue.
The gateway issue.
Yeah, it's the massive fork in the road. Before you can assess if a contract is valid or broken or unconscionable, you have to figure out what universe of law you're operating in. You must determine the governing law.
So we're dealing with 2 completely different legal universes here. Lay out the map for us. What are our options?
Broadly speaking, your 2 universes are the Uniform Commercial Code, specifically UCC Article 2, and the common law. And if you apply the rules from the wrong universe to your fact pattern, your entire essay will derail in the very first paragraph, and you will just bleed points for the next 10 pages.
Let's clearly define the borders of these universes. What lives in the UCC universe?
Well, UCC Article 2 governs the sale of goods. Now, in a legal context, goods has a very specific definition. We're talking about tangible, movable items at the time of identification to the contract for sale.
Meaning things you can physically put your hands on.
Exactly. Things you can load into the back of a freight truck. Oranges, commercial refrigerators, automobiles, lumber, manufactured widgets.
Because the UCC was designed to, lubricate the gears of interstate commerce, right?
That's
It wants merchants to be able to buy and sell physical inventory quickly and efficiently without getting bogged down in archaic legal formalities.
Precisely. Carl Llewellyn, the primary architect of the UCC, wanted the law to reflect actual business practices. Now, contrast that with the common law universe. The common law governs services and real estate. So if you hire an architect to design a building, or if you hire a painter for your house,
Or like an employment contract.
yes, employment contracts, or if you sell a plot of land in Montana, all of that is governed by the common law, which is heavily reliant on historical precedent and the restatement of contracts.
That sounds remarkably clean in theory. But we both know the law examiners despise clean divisions. They live in the gray areas.
Oh, they love the gray area.
Let's push this into a real-world edge case. Suppose a regional hospital system signs a $10 million contract with a medical tech company.
Okay.
The contract is for a massive, state-of-the-art MRI machine, which is clearly a tangible, movable good. But the contract also includes 5 years of weekly, highly specialized maintenance by the company's engineers, plus custom software integration.
Which is clearly a service.
Right. We have a hybrid contract. How on earth does a court or a student on an exam decide which universe applies?
That is the classic exam trap. When you encounter a mixed or hybrid contract like that, you must apply what courts call the predominant purpose test.
Predominant purpose test.
Right. You do not sever the contract into two halves. You look at the transaction as a singular, cohesive whole, and you ask, what is the primary thrust, the underlying gravamen of this deal?
You're looking for the center of gravity.
Yes. Are you primarily paying for that $10 million MRI machine, and the specialized maintenance is just an incidental necessity to keep the machine running? Or are you primarily paying for the brilliant minds of the software engineers to revolutionize your hospital's data system, and the physical hardware they left behind is just incidental to their labor?
I'd imagine to figure that out, a court looks at the billing breakdown. I mean, if 85% of that $10 million is allocated to the cost of the physical MRI machine, and only 15% is allocated to the hourly labor of the engineers.
The sheer financial weight pulls the entire transaction into the gravity of the UCC. The billing breakdown is a massive factor, yes. Courts also look at the language of the contract itself. Does it use words like buyer and seller, or words like client and contractor?
Oh, that makes sense.
The moment you determine the predominant purpose, you plant your flag in that legal universe, either UCC or common law, and you analyze every subsequent issue in the fact pattern through that specific lens. You pick your track and you do not look back.
So we've successfully navigated the gateway. We know what law applies. Now we need to determine if these people actually managed to form a legally binding contract in the first place.
Right.
The source notes provide this incredibly bizarre mnemonic for the entire formation process, and because it's so strange, it is permanently burned into my memory.
Right.
It goes, good frogs make outstanding apple cider donuts.
The absurdity is the point, really. When you're operating on 3 hours of sleep and high-stress adrenaline during a final, your brain will cling to those donuts. Let's unpack the letters G, F, M, O, A, C, D.
Okay, so the G stands for governing law. We just conquered that. That's your choice between UCC and common law.
Right. The F stands for formation. In an essay, this is where you simply state the baseline black letter rule to signal to the grader that you know the architecture of the law.
Just a quick sentence.
Yeah, you write something like, a valid contract requires mutual assent, consideration, and an absence of defenses.
Which naturally leads us to the M, the O, and the A.
M for mutual assent. This is the process of two minds coming together, and it's composed of an O offer and an A acceptance.
Got it.
You need one party to make an objective manifestation of their intent to be bound by specific, definite terms, and you need the other party to clearly accept those exact terms.
We'll dive deep into the specific definition of an offer in our masterclass section later because the source notes highlight it as a major point score. But for now, let's move to the C, because this is where the magic happens, right?
Yes.
This is where a polite conversation transforms into a legal weapon. Consideration.
Consideration is the absolute beating heart of American contract law. The formal definition is a bargained-for exchange.
Okay, translate that into something we can actually use. What separates a binding, enforceable contract from me, just like promising to give you a nice gift for your birthday?
Well, to have a legally binding contract, there must be a reciprocal exchange of legal value. One-sided promises are generally not enforceable.
So if I say, I'm going to give you my car tomorrow, and tomorrow I change my mind.
You cannot sue me. I offered you a gratuitous gift. But if there's a bargain for exchange, the dynamic shifts. I must give you something of legal value, and you must give me something of legal value in return. The promise must induce the detriment, and the detriment must induce the promise.
Let's look at the classic case from the 1890s that illustrates this perfectly, because it sounds like a plot from a Charles Dickens novel, Hamer v. Sidway.
Oh, a total classic.
We have a wealthy uncle and his teenage nephew. The uncle promises the nephew $5,000, which, by the way, was an absolute fortune in the 19th century.
Equivalent to well over 150 grand today.
Wow. Okay, so he promises him this money if the nephew abstains from drinking alcohol, using tobacco, swearing, and playing cards or billiards for money until his 21st birthday.
A sweeping prohibition on Victorian vices?
Exactly. The nephew takes the deal. He stays completely clean. He turns 21, writes to his uncle and says, I did it. The money is mine. The uncle writes back saying, great job. The money is safely in the bank for you.
Oh, but then...
But before the uncle actually transfers the funds, he dies. The executor of the uncle's estate, a man named Sidway, looks at this arrangement, scoffs, and flat out refuses to pay the nephew.
And Sidway, who is defending the estate's money, mounts a very logical argument. He says, where is the consideration here? A bargain for exchange requires a legal detriment. This nephew didn't suffer a detriment. He experienced a massive benefit.
Right. Giving up smoking and drinking saved his health.
And not gambling saved his money. The uncle received no tangible benefit, and the nephew suffered no harm. This was just a conditional gift. No consideration, no contract.
It's an incredibly intuitive argument. I mean, if I pay someone to eat their vegetables, I'm just giving them a gift tied to a healthy habit.
Right.
But the New York Court of Appeals completely rejected the estate's argument. Why did the court rule that avoiding healthy vices constitutes a legal detriment?
Because the court made a crucial distinction between physical harm and legal restriction. The law does not care about your cardiovascular health. It cares about your legal liberties.
Okay.
The court established a vital rule. Forbearance of a legal right is a valid legal detriment. At the time of the agreement, the nephew had a legally protected right to drink, smoke, and gamble. He voluntarily restricted his own lawful freedom of action in exchange for the uncle's promise.
So giving up a freedom is the detriment.
Exactly. He surrendered his legal liberty. That restriction constitutes a legal detriment, which satisfies the requirement for a bargain for exchange. Therefore, consideration existed, the contract was valid, and the estate was forced to pay the nephew his fortune.
So consideration isn't about economic loss or physical pain at all. It is purely about exchanging legal rights.
Yes.
Which brings us to a much more controversial application of this rule, the case of Fige v. Bohm. This case involves the settlement of a disputed claim, and it twists the concept of forbearance into a knot.
It is a phenomenal case for understanding public policy and contract law.
Here are the facts. A woman, Bohm, claims a man. Fige is the father of her child. She threatens to file a bastardy, proceeding a paternity suit against him to compel child support.
Okay.
Fige desperately wants to avoid the public scandal of trial. So they reach a private agreement. Fige will pay her a set amount of money, and in exchange, Bohm promises not to bring the paternity suit against him. That is her forbearance. She is giving up her legal right to sue.
A classic settlement agreement.
But here's the wild twist. After Fige has been paying for a while, blood tests are conducted. And the medical science proves absolutely, biologically, and undeniably that Fige is not the father.
Plot twist.
Right, so he stops paying immediately. Bohm sues him for breach of contract. And Fige's defense is brilliant. He says, her promise not to sue me was entirely worthless. She never had a valid claim to begin with because I am not the father. Since her claim was bogus, forbearing from it cannot possibly be a legal detriment. Therefore, no consideration. The contract is void.
And from a purely objective standpoint, Fige is correct. She gave up a lawsuit that she was destined to lose. But the court ruled against him, and they did so to protect the entire architecture of the legal system.
Wait, explain the policy behind that. Why reward a claim that turned out to be factually false?
Because the judicial system desperately wants to encourage people to settle disputes out of court. If every single settlement could be torn up 5 years later just by proving who would have actually won the underlying lawsuit, then settlements would be completely meaningless.
Oh, I see. No one would ever settle if the agreement lacked finality.
Exactly. So the court established the rule in Fige v. Bohm, forbearing from asserting a legal claim is valid consideration, even if the claim is ultimately invalid. so long as the person asserting the claim had a subjective good faith belief in its validity at the time of the agreement.
The subjectivity is the key, because Bohm honestly, genuinely believes Feige was the father when they made the deal. Her promise not to sue had legal weight.
Right. Her good faith beliefs synthesized the consideration, binding him to the contract even though he was biologically innocent.
It really demonstrates that contract law isn't always about objective scientific truth. It's often about protecting the stability of agreements made by reasonable people acting in good faith.
Absolutely.
But let me push back on this concept of promises creating consideration. What if a promise is inherently empty? What if I look at you and say, I promise to buy your car for $10,000 next week if I feel like it?
You've just created an illusory promise. You've dressed up a statement to look like a commitment, but you've retained an unlimited right to back out at your own whim.
Because I haven't actually committed to any restriction.
Exactly. Because you haven't restricted your future actions, your promise is an illusion. It cannot serve as consideration to bind me to the deal. The contract immediately fails for lack of mutuality of obligation.
That makes perfect sense for a blatant statement like, if I feel like it. But commercial contracts are rarely that obvious. Which brings us to one of the most famous cases in American jurisprudence, Wood v. Lucy, Lady Duff Gordon.
Ah, a masterpiece of judicial reasoning by Justice Benjamin Cardozo.
Let's set the stage. It's 1917. Lady Duff Gordon is not just a designer. She is a titan of industry. She's a survivor of the Titanic, a massive international celebrity, and an early 20th century fashion influencer.
Her mere endorsement on a dress or a hat causes sales to skyrocket.
Right. She enters into an exclusive dealing contract with a marketing agent named Wood. She grants Wood the exclusive right, subject to her approval, to place her endorsements on the designs of others. In return, Wood promises to split all profits generated from these endorsements 50-50 and to take out patents and copyrights to protect her brand.
It looks like a standard, highly lucrative agency agreement.
But Lady Duff Gordon is an opportunist. She realizes she doesn't really need Wood to get deals. She goes around him, secretly places her endorsement on a line of clothing for a major retailer, and pockets 100% of the profits.
Wow.
Yeah. Wood finds out and sues her for breach of their exclusive contract.
And Lady Duff Gordon's legal team unleashes an incredibly sneaky literalist defense.
They dissect the contract word by word. They say, look at this document. Wood demands 50% of the profits, yes. But nowhere in this contract does Wood explicitly promise to actually do anything.
Sneaky.
Right. He never promises to secure a specific number of endorsements. He never promises to work a set number of hours. Under the strict text of this agreement, Wood could have gone home, sat on his sofa for a year, and done absolutely nothing.
And because he had no explicit obligation to perform, his promise was illusory.
Therefore, there was no consideration, the contract is void, and Lady Duff Gordon is free to endorse whoever she wants.
It is a devastatingly clever argument. If read strictly literally, Wood didn't promise to lift a finger. But Justice Cardozo, writing for the New York Court of Appeals, refused to let a clever literalism destroy a clear commercial arrangement.
What did he do?
He looked at the entire context of the deal and delivered one of the most famous lines in contract law. He said, "The law has outgrown its primitive stage of formalism when the precise word was the sovereign talisman."
He essentially said, we aren't playing word games anymore, we're looking at the reality of the business.
Exactly. Cardozo noted that Lady Duff Gordon's sole compensation under this contract was a 50% split of the profits Wood generated. If Wood did nothing, she got nothing.
Right. That makes no sense for her.
Right. It would be entirely irrational for a massive celebrity to sign away her exclusive rights to someone who had no obligation to actually try to sell them. Therefore, Cardozo concluded the entire contract is instinct with an obligation.
Instinct with an obligation. He read a phantom promise into the blank space of the contract.
He ruled that by accepting the exclusive agency, Wood implicitly promised to use his reasonable effort to generate profits. That implied duty of good faith and reasonable efforts filled the silent gap in the text, provided the necessary legal detriment, and saved the contract from being an illusion.
And Lady Duff Gordon was held liable for breach.
Yes.
Man, if Cardozo hadn't implied that duty of good faith, the entire modern industry of commercial agents, talent managers, and real estate brokers would have been paralyzed overnight.
Absolutely paralyzed.
So we've successfully navigated governing law, formation, mutual assent, and consideration. The final letter in our donut mnemonic is D for defenses, because even if you have an offer, an acceptance, and consideration, the law might still step in and refuse to enforce the contract.
Right, and the most prominent defense you'll encounter on an exam is the Statute of Frauds.
The source notes provide the classic mnemonic for this on Y legs. If a contract falls into one of the MY legs categories, it is vulnerable to the Statute of Frauds. Now, explain the historical purpose of this statute, because the name itself is confusing. It doesn't mean the contract is fraudulent.
Right. The name refers to the prevention of fraud. The original statute for the prevention of frauds and perjuries was passed by the English Parliament in 1677.
Okay, going way back.
Yeah. At that time, in English courts, the actual parties to a lawsuit were not allowed to testify on their own behalf because they were considered inherently biased.
Wait, really?
Yeah. So to prove a contract existed, you had to bring in third-party witnesses. This led to massive amounts of bribery and perjury, with people hiring fake witnesses to swear an oral contract existed.
Oh, that sounds like a mess.
It was a disaster. Parliament finally said, enough. For certain high-stakes transactions, we will no longer accept the word of witnesses. You must produce a physical writing signed by the party you are trying to enforce it against, or the court will not hear the case.
So, which modern contracts are considered so high stakes that they trigger the MY legs requirement for a written signature? Let's walk through the acronym.
Okay, M stands for marriage. This doesn't mean the marriage vow itself, but contracts made in consideration of marriage. Prenuptial agreements or a promise to transfer property upon marriage must be in writing.
Makes sense. Why?
Y stands for year. This is tricky. It applies to contracts that, by their explicit terms, absolutely cannot be fully performed within 1 year from the date they are made.
So if I hire you to work for exactly 13 months, it needs a writing.
Yes. But if I hire you for the rest of your life, it might not, because you could theoretically die tomorrow fulfilling the contract within a year.
Morbid, but logical.
L stands for land. Any contract transferring an interest in real estate, selling a farm, a long-term lease, granting an easement must be written. Land was the basis of all wealth in 17th century England, so they demanded a paper trail. E stands for executor. If the executor of an estate promises to pay the deceased person's debts out of the executor's own pocket, it requires a writing.
Got it. G.
G stands for goods. Under UCC Article 2, contracts for the sale of goods priced at $500 or more must be in writing.
And finally, S.
S stands for suretyship. This is when you promise a creditor that you will pay the debt of another person if they default. You're acting as a guarantor.
My legs.
Yeah.
If your fact pattern involves any of those, and there is no signed writing, the defendant has a massive shield. But what if the defense isn't a technical rule, like a missing signature? What if the defense is simply that the contract is shockingly, morally repulsive?
That brings us to the defense of unconscionability.
Which is highlighted by the landmark case of Williams v. Walker Thomas Furniture Co.
Yes. This is a foundational case for modern consumer protection law, decided by the D.C. Circuit in 1965.
The facts here are infuriating. Mrs. Williams was a single mother of 7 children living in Washington, D.C. on a very limited government stipend. Over the course of 5 years, she purchased various household items from Walker Thomas Furniture on an installment credit plan. She bought a stereo, a washing machine, beds for her children.
And buried in the dense boilerplate fine print of the installment contract was a profoundly aggressive provision known as a cross-collateralization clause.
Explain the exact mathematical trap of cross-collateralization, because it is insidious.
Usually, if you buy a washing machine on credit, the machine itself is the collateral. When you pay off the balance of the washing machine, you own it free and clear. If you later buy a stereo and default on the stereo, they can only repossess the stereo.
Right, that's what anyone would expect.
But Walker Thomas used a dragnet clause. It stated that every time Mrs. Williams made a payment, that payment was not applied to the oldest debt. Instead, it was mathematically prorated and spread across the balances of all the items she had ever purchased from them.
The result being that the balance on her very first purchase, say a stereo from 5 years ago, never reaches zero until the balance on her most recent purchase reaches zero.
Precisely. She never held the title to a single item. Every single piece of furniture she owned was held hostage by the debt of the newest item.
That's awful.
It was. When she eventually bought a stereo and subsequently fell behind on a payment, Walker Thomas didn't just repossess the stereo. They used the cross-collateralization clause to repossess the washing machine, the beds, the tables, everything she had bought over the past 5 years, even though she had paid hundreds of dollars toward them.
The court looked at this and said, this crosses a line. But courts are terrified of striking down contracts just because they seem unfair, right? They needed a rigorous test.
The D.C. Circuit, led by Judge J. Skelly Wright, used this case to crystallize the two-pronged test for unconscionability. To invalidate a contract, a court generally requires a showing of both procedural unconscionability and substantive unconscionability.
Let's break those down. Procedural unconscionability asks how the contract was formed, correct?
Yes. Was there a meaningful choice? Or was it an adhesion contract shoved in front of a vulnerable party? The court looked at Mrs. Williams' lack of education, the immense inequality of bargaining power, and the fact that this labyrinthine dragnet clause was buried in fine print that even a lawyer would struggle to parse. The procedural process was deeply flawed.
And substantive unconscionability examines the actual terms of the deal.
Right. It asks if the terms are so outrageously oppressive, so commercially unreasonable, that they shock the conscience of the court. The court found that keeping a woman's entire household of essential goods hostage over a single missed payment on a luxury item was substantively oppressive.
So because both the procedural and substantive prongs were met, the court refused to enforce the cross-collateralization clause.
Yes, exactly.
It is a powerful shield against predatory corporate behavior. But what happens if you're advising a client or analyzing a fact pattern and traditional formation simply fails? Let's say there was no consideration, or a real estate deal wasn't in writing and violated the Statute of Frauds. The defendant breached their oral promise, and your client is severely damaged. Are they just out of luck?
Not necessarily. Contract law has a basement level of equitable safety nets. When the strict rules of formation fail, we move to the alternative theories of recovery. The study notes give us the mnemonic PQM Performance Queens March.
When the king's rigid rules fail, the performance queens march in to save the day in equity.
I love that, yes.
Right.
The P stands for Promissory Estoppel, which is codified in Section 90 of the Restatement. This is a massive doctrine.
Okay, how does it work?
It applies when there is no formal contract, but one party made a clear and definite promise. They reasonably should have expected the other party to rely on that promise. The other party did, in fact, rely on it to their substantial detriment, and injustice can only be avoided by enforcing the promise.
Let me create a hypothetical. I promise to give my niece $50,000 for her college tuition. No consideration, it's just a gratuitous promise. But based on that promise, she quits her part-time job, enrolls in an expensive private university, and signs a non-refundable lease for an apartment. Then I change my mind and refuse to pay.
Under strict formation rules, she loses. No bargain for exchange.
Right.
But under promissory estoppel, she wins. You made a clear promise. You knew she would rely on it to go to school. She took detrimental action by quitting her job and signing the lease. And it would be a gross injustice to let you pull the rug out from under her now. The court will stop you, prevent you from denying the promise.
That is the P. What about the Q?
Q is for quasi-contract, also known as restitution in this context. This is fascinating because it's not a contract at all. It's a legal fiction created by a judge to prevent unjust enrichment.
The classic example here is the mistaken painter, right?
Yes. A painter is hired to paint a house at 100 Main Street. By mistake, he goes to 102 Main Street and starts painting. The owner of 102 Main Street is sitting on his porch, drinking iced tea, watching the painter transform his peeling house.
And he just lets it happen.
Right. He knows the painter has the wrong address, but he says absolutely nothing. He lets him finish the job, then says, "Thanks for the free paint job. We never signed a contract."
And the homeowner is technically right. There was no offer, no acceptance, no mutual assent.
But the court will intervene with a quasi-contract. They'll say, you received a tangible benefit, you had the opportunity to reject it but chose to accept it, and it would be grossly unjust for you to retain that enriched value without paying for it. The court will force the homeowner to pay the fair market value of the paint job.
And finally, the M in PQM.
M for moral obligation. This is a very narrow, fragile exception. Generally, a moral duty to pay someone is not legally enforceable. But in some jurisdictions, if a person receives a material benefit in an emergency, say, a doctor saves your life while you are unconscious on the street, and later, when you wake up, you promise to pay the doctor $1,000 for saving you, that subsequent promise might be enforceable based on the moral obligation arising from the prior benefit.
Okay, so we've successfully navigated phase one. we've built a valid contract, or we've rescued it with an alternative theory. The paper is signed, the deal is set. Now we enter the real world. Phase 2.
The messy part.
Exactly. How does the law handle the messy, unpredictable reality of human beings actually trying to perform the duties they promised?
Well, the transition from the sterile environment of formation to the chaos of performance is where most legal disputes actually ignite. And the standard by which courts judge your performance depends entirely on that gateway issue we discussed in the very beginning.
The choice of law, UCC versus common law.
Exactly. Let's start with the UCC, which governs the sale of goods. The UCC imposes a standard that is terrifying in its strictness. It's found in UCC Section 2601, and it's known as the perfect tender rule.
Define perfect.
It means exactly what it sounds like. The seller must deliver goods that conform to the exact specifications of the contract in every single microscopic detail.
Oh, wow.
If you're a buyer and you order 10,000 blue widgets, and the seller delivers 9,999 blue widgets and one single widget that is slightly cyan, the perfect tender rule gives you the absolute right to reject the entire shipment. You can send all 10,000 back and declare a breach.
But wait, let me push back on that, because that sounds completely unhinged. If I'm the buyer, wouldn't it be wildly inefficient to blow up a massive commercial transaction over one slightly off-color widget? Why wouldn't the law just force me to accept the good ones, ask for a refund on the one cyan one, and move on with my business? Why does the UCC allow for such draconian rejection?
Because the UCC operates in the high-speed world of commodities and commercial trade. In a fluctuating market, buyers need certainty and speed. If a shipment is defective, even slightly, the buyer shouldn't be forced into complex, drawn-out negotiations over price reductions and partial acceptances while their own assembly line grinds to a halt.
I see.
The perfect tender rule gives the buyer a bright-line nuclear option. If it's not perfect, send it back immediately and buy from someone else, which we call covering. It forces sellers to be meticulous, which ultimately increases the efficiency of the entire marketplace.
It is a ruthless efficiency. But what about the common law? If I hire a contractor to build a custom house and they use the wrong color nails on the floorboards in the attic, I can't just declare a breach, tear down the house, and refuse to pay them, right?
No, you cannot. The common law, which governs services and construction, completely rejects the perfect tender rule. Construction is inherently messy. Absolute perfection is practically impossible. Instead, the common law uses the doctrine of substantial performance.
How much is substantial?
It means that if a party has performed the essential primary purpose of the contract and the remaining defects are minor or unintentional, the contract remains valid and enforceable. The non-breaching party cannot cancel the deal.
So they still have to pay.
They're obligated to pay the contract price, but they are allowed to deduct the cost of fixing the minor defects. The house stands, the builder gets paid, minus the cost of replacing the attic nails.
That leads us directly into one of the most notoriously confusing areas for law students, deciphering the difference between a promise and a condition during performance. Let me try an analogy.
Sure.
I like to think of a promise as a standard to-do list. Paint the house, mow the lawn, pay me $500. A condition, on the other hand, is like a heavy, locked door standing in the hallway of the contract. I will pay you $500 if the bank approves my loan. The to-do list creates a duty to act, but the locked door triggers whether that duty even exists.
That is an excellent structural analogy. A promise is a commitment to do something or refrain from doing something. If you fail to do it, you have breached the promise, and the other party can sue you for damages. But a condition is an event not certain to occur that must occur before performance under a contract becomes due.
So if the condition fails, if the locked door never opens, what happens?
If a condition fails, the party's duty to perform is entirely discharged. They don't have to do the thing, and they cannot be sued for breach because their obligation was never activated.
But the source notes explicitly warn us that courts harbor a deep hatred for conditions. There's a famous legal maxim, the law abhors a forfeiture. Why are courts so hostile to conditions?
Because conditions operate like a guillotine. They're binary. If a condition is not perfectly met, the entire deal collapses, and one party might lose everything they have invested in preparing for the contract. It causes a disproportionate forfeiture of value.
So courts try to avoid them.
Absolutely. If the language of a contract is ambiguous, if it's not crystal clear whether a clause is a promise or a condition, judges will bend over backwards to interpret the clause as a promise. They'd much rather let the contract survive and award some minor damages for the failure rather than let the whole deal implode over a technicality.
Which brings us to a masterclass case study on promises, conditions, and the concept of waiver Burger King v. Family Dining. This case plays out like a corporate soap opera.
It is a phenomenal illustration of how the strict text of a contract collides with the messy reality of a long-term business relationship.
Let's set the scene. It's the early 1960s. Burger King is a relatively modest hamburger operation, mostly confined to Florida. The founder, James McLemore, is desperate to expand up the East Coast. He reaches out to his old Cornell University fraternity brother, a man named Carl Ferris, who runs a company called Family Dining in Pennsylvania. They negotiate what is known as a territorial agreement.
And they negotiate an absolute blockbuster of a deal. Burger King grant Family Dining an exclusive territory encompassing Bucks and Montgomery counties in Pennsylvania.
And the exclusivity period is 90 years. For nearly a century, Burger King promises that they will not allow anyone else to open a restaurant in those counties. Family Dining has a monopoly.
But Burger King isn't just going to hand over a 90-year monopoly for nothing.
Right.
The exclusivity was subject to a strict development rate. The contract stipulated that Family Dining had to open or have under active construction 10 restaurants within the first 10 years, one per year.
A very clear timeline.
Yes.
So performance begins. Do they hit their targets?
At first, yes. Restaurants 1 and 2 open on time. But then the realities of commercial real estate and construction set in. Zoning boards delay permits. Construction crews face weather delays. The third restaurant is a couple of months late. The fourth is 6 months late. By the time they are building the fifth and sixth restaurants, they are over a year behind the contractual schedule.
If they're missing the deadlines, why doesn't Burger King cancel the contract?
Because of the human element. McLemore, the founder, testified that as long as Family Dining was generally moving forward and aggressively trying to build, he wasn't going to call a default on a technical timeline. He knew his old friend Ferris was taking on immense financial risk to establish the Burger King brand in a new state.
So Burger King let the delays slide.
They explicitly, through their conduct, waived the strict timeline.
But then Wall Street enters the chat.
Exactly. Fast forward to the late 1960s, Burger King is acquired by the Pillsbury Company. It transforms from a founder-led startup into a massive, ruthless corporate entity. McLemore is kicked upstairs to chairman, and a new, aggressive CEO takes over operations.
And they want out of the deal.
Oh, this new corporate leadership looks at the map, sees the booming population in Bucks County, realizes the territory could easily support 30 or 40 restaurants, and they decide they desperately want out of this 90-year exclusivity deal with Family Dining.
They start hunting for a loophole, and they find one. Family Dining happens to be a few months late on opening their 9th restaurant.
The new Burger King executives immediately pounce. They send a formal letter declaring Family Dining in default of the development rate and attempt to terminate the entire exclusivity agreement.
We have a massive legal showdown. Let's look at the arguments. Burger King argues that building a restaurant every single year was a promise, and Family Dining broke that promise by being late. How does the court analyze the development rate?
Well, the court looked at the structure of the contract and disagreed with Burger King. They ruled that the development rate was not a promise, it was a condition subsequent.
Stop right there. Define a condition subsequent. We know a condition precedent is an event that must happen before a duty arises.
Right. A condition precedent unlocks the door to a duty. A condition subsequent is a rare event that extinguishes a duty that already exists. The court reasoned that Burger King's duty to provide exclusivity began immediately on day one. The failure of Family Dining to build on time was an event, a condition subsequent, that would divest Family Dining of the exclusivity they already held.
But wait, if it's a condition subsequent, and the condition failed because they were late on the 9th restaurant, then the exclusivity should be divested.
Yeah.
Burger King should win. Why did Burger King lose this case?
Because of the doctrines of waiver and forfeiture, the court looked at the decade-long history of the relationship. For years, Burger King allowed Family Dining to build late. They never demanded literal, strict compliance with the timeline. The court ruled that by their continuous conduct, Burger King had waived the condition of strict punctuality.
Let me play the corporate devil's advocate here. Burger King was just being nice for a few years. Why should their past leniency legally prevent them from enforcing the clear text of the contract when they finally decide they want to? we have a contract.
The law demands fair warning. The rule is this: if you have established a clear pattern of waiving a condition, you cannot suddenly, overnight, reinstate strict compliance and drop the hammer. To reinstate the condition, Burger King was legally required to give family dining clear, unequivocal notice that leniency was over and provide them a reasonable amount of time to get back on schedule. Burger King didn't do that. They just tried to ambush them with a termination letter.
And the court also relied heavily on the abhorrence of forfeiture, didn't they?
They did. The court cited the Restatement of Contracts, which allows a judge to excuse the non-occurrence of a condition if enforcing it would result in an extreme forfeiture. Family Dining had invested millions of dollars, taken massive risks, and successfully established the brand in Pennsylvania. To strip them of 76 remaining years of exclusivity just because a single restaurant was a few months late would be a grossly disproportionate penalty.
So the court ruled in equity.
The exclusivity remained intact.
It's a brilliant example of how the strict letter of the law must sometimes yield to the equitable history of the party's conduct. But let's transition from million-dollar corporate deals to the reality most of us face. Most people don't negotiate 90-year contracts over cigars with their fraternity brothers. We interact with adhesion contracts.
Adhesion contracts are the inescapable reality of modern commerce. They're standardized, mass-produced, boilerplate contracts drafted entirely by a powerful corporate entity and presented to the consumer on a strict take-it-or-leave-it basis.
There's zero negotiation.
Zero. You either sign the rental car agreement or you walk. You either click, "I agree" on the software update, or your phone stops working.
Which brings us to one of the most frustrating, blood-boiling cases in the source material, C&J Fertilizer, v. Allied Mutual Insurance Co. This case shows the absolute worst-case scenario of adhesion contracts.
It really is a stark illustration of the judicial system struggling to catch up with 20th century commercial realities.
Here's the story. We have a 37-year-old farmer in Iowa who runs a fertilizer plant. He knows his inventory of agricultural chemicals is highly valuable, so he sits down with an agent from Allied Mutual to purchase burglary insurance. They have explicit conversations about ensuring his inventory is protected against theft. He buys the policy and pays his premiums.
A standard pursuit of commercial security?
One weekend, the inevitable happens. The plant is robbed. Someone breaks in and steals nearly $10,000 worth of chemicals. And here's the crucial detail. The burglar was evidently a highly skilled professional. They managed to pick the lock on the exterior front door of the facility without leaving a single scratch or mark on the outside of the building.
Which is impressive, but
however, once they were inside the warehouse, they used heavy tools to completely smash the lock on the interior room where the chemicals were stored. There were muddy tire tracks across the floor, a shattered inner door, and massive inventory missing. It was undeniably a burglary.
But Allied Mutual Insurance denied the farmer's claim. They refused to pay a single cent.
Why? On what possible grounds?
They pointed to a definition buried deep within the policy. On page 3, in dense 6-point font, the policy defined the word burglary. It stated that for coverage to apply, there must be a felonious entry by actual force and violence, of which there must be visible marks made by tools or explosives upon the exterior of the premises.
So because the burglar was highly skilled and picked the front lock cleanly, the insurance company argues this doesn't meet our microscopic definition of a burglary, claim denied. Now I have to play the classical law professor here. I have to argue for the sanctity of the text. Didn't the farmer sign the contract?
He did.
Didn't he agree to the terms? The doctrine of caveat emptor buyer beware dictates that he should have read the fine print before signing. He is bound by his signature, period.
That is the rigid 19th century classical view of contract law. But the Iowa Supreme Court recognized that applying classical negotiation rules to modern mass-market adhesion contracts leads to profound injustice. A farmer buying insurance cannot realistically negotiate the definitions in a 10-page boilerplate policy.
So what did the court do?
So the court bypassed classical formation and employed a modern doctrine known as the reasonable expectations doctrine.
How does that doctrine operate to save the farmer?
The court ruled that the objectively reasonable expectations of applicants regarding the terms of insurance contracts will be honored, even if a painstaking study of the fine print would have negated those expectations.
Oh, wow.
Yeah. The restatement, second of contracts, states that a party who adheres to a standard form does not assent to a specific term if the drafter has reason to believe that the adhering party would not have accepted the agreement if they had known that term was in there.
Put simply, The farmer bargained for burglary insurance. A reasonable person in society expects that if a criminal breaks into their warehouse and steals their inventory, leaving smashed doors on the inside, the insurance will cover it. No reasonable person expects that their financial ruin depends on whether the burglar was clumsy enough to scratch the paint on the front door.
Exactly. The court noted that this bizarre, hyper-technical definition of burglary completely eviscerated the dominant purpose of the transaction. It wasn't a definition, it was an escape hatch designed to avoid liability.
And the Iowa Supreme Court didn't just stop at reasonable expectations, did they?
No, they threw the book at them. They also applied the doctrine of an implied warranty of fitness. Historically, warranties apply to the sale of physical goods. If you buy a lawnmower, there is an implied warranty that the blades will spin and cut grass.
Right.
But the court essentially said that modern insurance is marketed and sold like a manufactured product. It is a mass-produced sale of promises. And this specific insurance policy was entirely unfit for its intended purpose. It failed to do the very job it was sold to do.
Which is to insure against burglary.
Right. Furthermore, the court brought up unconscionability, stating that hiding a liability-avoiding exclusion inside an esoteric, counterintuitive definition of a crime buried in microscopic font was both procedurally and substantively unconscionable. The farmer won, and the insurance company was forced to honor the claim.
It's a triumph of equity over boilerplate text. So what does this entire Phase 2 teach us? It teaches us that performance is rarely flawless, that conditions can be excused to prevent catastrophic forfeitures, and that burying traps in fine print will not always save a corporation from their fundamental obligations. But what happens when the wheels completely fall off? What happens when there's no substantial performance, when the waiver fails and someone just flat out walks away from the deal? We enter the final act of our deep dive, breach and remedies.
When a contract shatters, we turn to the math, because the core overriding principle of contract remedies is entirely economic.
Lay out the fundamental rule of damages for us, because it is very different from tort law.
The primary goal of contract remedies is strictly forward-looking compensation. We refer to these as expectation damages. The court's singular objective is to place the non-breaching party in the exact financial position they would have occupied had the contract been fully and perfectly performed.
It's about fulfilling the expectation of the deal. It is absolutely not about punishment, is it?
No. Punitive damages money awarded specifically to punish a wrongdoer are virtually never awarded in contract law, regardless of how malicious or intentional the breach was. Contract law is amoral. If you break a promise, you simply have to pay the economic value of that promise.
What's the formula?
The formula for expectation damages is losses caused plus gains prevented minus any savings realized by the breach.
Let's look at how this mathematical formula creates explosive controversy when applied to construction contracts. This is where the battle lines are drawn between the cost of performance measure and the diminution in value measure. The foundational case here is another Cardozo classic, Jacob & Young's v. Kent.
Ah, the famous reading pipe case. It is a staple of every first-year contracts class.
A wealthy man, Kent, hires a builder, Jacob & Young's, to construct a lavish country mansion. Kent is very particular. The contract explicitly, clearly states that all the plumbing inside the walls of the house must be made of Reading manufacturer pipe. Reading was a specific brand name.
But the builder makes a mistake during the chaotic construction process.
They install a different brand of pipe. They use co-hose pipe instead of Reading pipe. Now, it is undisputed by experts that the co-hose pipe was of exactly the same quality, the same weight, the same durability, and the exact same market value as the Reading pipe. It just had a different brand name stamped on it.
Kent discovers this after the house is built and the walls are sealed. He's furious. He refuses to make the final payment to the builder, and he demands that the builder rip open the plastered walls of his newly finished mansion to tear out the co-hose pipe and install the Reading pipe.
The builder refuses and sues Kent for the final payment. Now let's look at the damages. If the court strictly enforced the contract and awarded Kent the cost of performance, the cost to actually fix the breach, the builder would have to pay an astronomical sum of money to destroy the house just to swap out functionally identical pipes.
Judge Cardozo, writing for the majority, stepped in to prevent that. He introduced the doctrine of economic waste. He reasoned that because the breach was unintentional and because the pipes were identical in quality, forcing the destruction of the house would be grossly disproportionate to the actual harm suffered.
So what did they do?
The court refused to award the cost of performance. Instead, they awarded Kent the diminution in value of his property.
And what was the diminution in value? What is the difference in market value between a mansion with Reading pipe and a mansion with co-host pipe?
The difference was $0. The market value of the house was entirely unaffected. Therefore, Kent was awarded nominal damages, basically nothing, and he was ordered to pay the builder the final balance owed on the contract.
It makes economic sense. But let's contrast that with a case where this exact same logic, the diminution in value rule, resulted in what many scholars consider a massive, heartbreaking injustice. The infamous case of PV House v. Garland Coal and Mining Co.
Oh, this is a highly controversial case from the Oklahoma Supreme Court in 1962, and it forces us to confront the limits of market value economics.
The PV Houses were a farming family in Oklahoma. They owned a farm with coal deposits. Garland Coal approaches them and wants to lease the land for strip mining. The PV Houses agree, but they insist on a specific, non-negotiable clause being added to the contract. When the mining operations are complete, the coal company must perform remedial earthwork to restore the land.
Right. They must fill in the massive kits, smooth out the topsoil, and leave the farm usable.
This wasn't boilerplate. The PV Houses specifically bargained for this promise.
The coal company signs the contract. They mine the coal, extract their massive profits, and then, in an act of calculated corporate defiance, they flat out refuse to fix the land. They pack up their equipment and leave the PV House farm a scarred, dangerous, unusable lunar landscape.
The PV Houses sue for breach of contract, demanding the cost of performance. Expert testimony establishes that the cost for a dirt-moving company to come in and fulfill the promise to fix the land would be $29,000.
But Garland Coal, backed by a team of lawyers, argues for the Jacob and Young's precedent. They argue for diminution in value. They present economic evidence proving that even if they spent the $29,000 to painstakingly restore the land, the total open market value of the farm would only increase by $300.
I'm going to lose my mind here. Who cares about the open market value? The coal company explicitly promised to fix it. That was the entire reason the farmers agreed to let them destroy their land in the first place. The coal company calculated that it was cheaper to breach the contract than to perform it. How on earth did the court rule?
Shockingly, the Oklahoma Supreme Court sided with the coal company. They applied the concept of economic waste. They ruled that forcing a company to spend $29,000 to achieve a mere $300 increase in market value was grossly disproportionate and economically inefficient. They awarded the PV Houses a grand total of $300.
That is infuriating. It completely strips the moral weight of a promise out of the law.
It is widely criticized in modern law schools. The profound flaw in the court's reasoning is that they completely ignore the concept of subjective value or idiosyncratic value.
Because it's their home.
Exactly. The PV Houses didn't view their farm as a fungible commodity to be sold on the open market. It was their family home. They derived massive subjective value from living on restored land, which the $300 market value metric utterly failed to capture. Modern courts are much more hesitant to apply the diminution in value rule when the breached promise involves a core, bargained-for purpose of the contract rather than an incidental detail like the brand name of a pipe.
Let's look at another scenario where the standard expectation damages formula losses plus gains minus savings completely falls apart and fails to capture the economic reality. We have an analogy in the study notes that I call the lost volume sucker play.
This is a good one.
Let's put you, the listener, in a hypothetical. Let's say you're selling your used Honda Civic on Craigslist for $10,000. A buyer agrees to buy it on Tuesday, but on Wednesday they back out and breach the contract. On Thursday, you sell that exact same Honda Civic to your neighbor for $10,000. Under the standard formula, you expected $10,000, you ended up with $10,000, so your damages are zero, correct?
Yes. For a private, one-off seller with a single unique item, you have been made completely whole. Your damages are zero.
But let's change the identity of the seller. What if you aren't a guy on Craigslist? What if you are a massive Honda dealership with a lot full of 50 identical Honda Civics? A buyer signs a contract to buy one for $10,000, then breaches and walks away. The next day, a different customer walks onto the lot and you sell that exact same car to them for $10,000. Under the standard math, you got your $10,000. Did you break even?
Absolutely not. And this introduces the crucial UCC concept of the lost volume seller.
Explain the math. Why didn't the dealership break even?
Because the dealership has an essentially unlimited inventory. If the first buyer had not breached, The dealership would have sold a car to the first buyer on Tuesday, and they still would have sold a car to the second buyer on Thursday.
Oh, they would have made 2 sales.
Exactly. They would have made 2 distinct sales, resulting in 2 distinct profit margins. Because of the first buyer's breach, they only made 1 sale. They have permanently lost the volume of that transaction.
It's like buying a ticket to a movie and walking out. The theater can't sell your empty seat once the movie starts. They've lost that revenue forever. So how does the UCC fix this?
UCC Article 2 allows a qualifying lost volume seller to completely bypass the standard market price formula. Instead, they're entitled to recover the specific lost net profits, including an allocation for reasonable overhead that they would have realized on that specific breached sale. It is the only mathematical way to put the dealership in the position they would have occupied had the contract been performed.
But what happens when money, regardless of how you calculate it, simply isn't enough to fix the problem? What are our alternative remedies when cash won't make you whole?
When legal damages money are inadequate, the court turns to equitable relief. There are 2 primary vehicles here, restitution and specific performance.
We touched briefly on restitution with the quasi-contract of the mistaken painter. How does it function as a remedy for a breached contract?
Well, expectation damages look forward to what the contract would have been. Restitution looks backward. Its goal is to wind the clock back to the moment before the contract ever existed. It aims to prevent unjust enrichment by stripping the breaching party of any benefit they received during partial performance and returning it to the non-breaching party.
But the heavy hitter in equitable remedies is specific performance. This is when the judge bangs the gavel and actually forces you to do the exact thing you promised to do.
Yes, but courts are extremely historically reluctant to grant it. The study notes provide a strict checklist. To obtain an order for specific performance, you must first prove beyond a doubt that monetary damages are strictly inadequate to compensate you. Furthermore, you generally must prove that the subject matter of the contract is entirely unique.
Land is the classic example, right?
Yeah.
Because under the common law, every single parcel of real estate is considered legally unique.
Correct. No 2 plots of land are identical. So if a seller signs a contract to sell you their farm and then breaches and tries to sell it to someone else for a higher price, a court will routinely grant specific performance, ordering the seller to transfer the deed to you. Money can't buy you that exact farm.
What about the sale of goods under the UCC? A Honda Civic isn't unique.
Exactly. For fungible goods, you just take the money and buy a replacement. But consider the fascinating case of Emmanuel Law Outlines v. Multi-State Legal Studies.
Let's look at it.
Emmanuel was a publisher who entered into a contract to print custom-made bar review study materials specifically designed for multi-state's proprietary courses. After Emmanuel had printed thousands of these books, Multi-State breached the contract and refused to pay or take delivery.
Why couldn't Emmanuel just turn around and sell the books on Amazon to cover his losses?
Because the goods were entirely customized. They were essentially useless to anyone else on the open market. Emmanuel couldn't cover his losses through resale. The court recognized that monetary expectation damages were inadequate because there was no market for the goods. Therefore, the court ordered specific performance, compelling the breaching buyer to physically take the custom books and pay the full contract price.
But there is a massive, impenetrable constitutional wall when it comes to specific performance, isn't there? You cannot force someone to perform a personal service.
Correct. That is a fundamental barrier. The 13th Amendment of the U.S. Constitution prohibits involuntary servitude. A court will never grant specific performance to force an employee to work, or an artist to paint a portrait, or a quarterback to play football. Furthermore, from a practical standpoint, courts despise the idea of having to supervise the quality of a forced human performance.
Right. If you force an angry painter to paint your house, they're going to do a terrible job, and the court doesn't want to arbitrate the quality of every brushstroke. Oh. But if you can't force them to work for you, can you stop them from working for your competitor?
That is the alternative equitable weapon, the negative injunction. And the seminal case here is from 1852 England, Lumley v. Wagner.
Johanna Wagner was an incredibly famous opera singer.
She was a superstar. She signed an exclusive contract to sing at Mr. Lumley's theater in London for 3 months. But a rival theater owner, Mr. Guy, offered her significantly more money, and she breached her contract with Lumley to go sing at the competitor's opera house.
Lumley sues. He wants specific performance. But as we just established, The court cannot force her to take the stage and sing against her will.
The court acknowledged the limitation. They said, we cannot compel her to sing. But they issued a revolutionary ruling. They said, while we cannot compel her to perform her affirmative promise, we can compel her to abstain from the commission of an act which she has bound herself not to do. Because she signed an exclusive contract, the court issued an injunction legally preventing her from singing at the rival theater for the entire duration of her contract with Lumley.
If you won't sing for me, I will make sure you don't sing for anyone else. It's a brilliant piece of legal leverage that is still used against professional athletes and entertainers today.
All the time.
Okay, we have absorbed the law, we've analyzed the landmark cases, we've navigated the treacherous rules of formation, the rigid standards of performance, and the economic math of remedies. Now, how do we weaponize this knowledge? How do you, the listener, sitting in a timed exam, translate this into an A+ essay? Let's dive into Part 4 of the masterclass.
The professor's notes in the source material are incredibly explicit about how to approach a contracts essay. The absolute key to a top score is unyielding structural discipline.
Give us the architectural blueprint. What is the analytical flow?
An exam essay must follow a rigid step-by-step template. The biggest mistake students make is reading a juicy fact pattern about a terrible breach of contract and immediately writing about the breach.
You can't just skip ahead.
You cannot do that. You must build the house before you can argue about it burning down. You must prove the contract exists before you can discuss its destruction.
Step 1.
Step 1 is always the gateway. Governing law. You explicitly state, this contract involves the sale of a tractor, a tangible good, therefore UCC Article 2 governs. Step 2 is formation. You march through your MCDS mnemonic mutual assent, consideration, defenses. Step 3, if formation fails, you rapidly analyze alternative theories, promissory estoppel, or quasi-contract.
And if formation succeeds, we move to Step 4, performance. And the notes give us another vital mnemonic for the performance checklist, SPWCEA. Let's define these so the listener can write them down.
S stands for standard of performance. Is it perfect, tender, or substantial performance? P stands for parole evidence rule. Are they trying to introduce outside oral promises that contradict the written text? W stands for warranties. Were there express or implied warranties breached? C stands for conditions. Did a condition fail, excusing performance? E stands for excuses. Was performance rendered impossible by an act of God? And A stands for anticipatory repudiation. Did one party clearly state they were going to breach before the deadline even arrived?
You run that checklist in your head to spot the issues. And then Step 5 is remedies. What is the monetary or equitable fix? It really is like a geometry proof. You have to show every single step of the work. And to write those steps, the notes emphatically demand the IRAC method.
Issue, rule, application, conclusion. Every single paragraph of your essay should follow this structure. And the most critical part is the rule. You must recite the black letter law abstractly before you apply it to the facts of the story. Do not blend them. State the rule, then apply the facts.
There is a massive underlined warning from the professor's notes here. Don't fight the prompt. What exactly does that mean?
It means scope is everything. If the exam prompt explicitly asks you, analyze whether a valid contract was formed up to the Statute of Frauds, you must stop there. If you get excited and write 3 brilliant, legally flawless pages analyzing the parole evidence rule and expectation damages, you will receive absolutely 0 points for that work.
Oh, that's brutal.
Because it is outside the scope of the question asked. You've wasted precious time, alienated the grader, and lost points you could have earned elsewhere. Answer the specific question asked, and nothing more.
That is crucial tactical advice. What about the multiple choice section of the bar or a final? The notes mention a technique called the measuring stick.
This is a phenomenal strategy, particularly for tricky, convoluted questions regarding the Statute of Frauds or conditions. The advice is to read the fact pattern carefully, identify the core legal question, and then physically cover up the 4 answer choices with your hand.
Blind yourself to the options.
Yes. Because the test writers have deliberately designed the 3 wrong answers to sound incredibly logical and persuasive. If you look at them first, they will implant false logic in your brain. Instead, cover them up, actively define the rule in your own head, and make your conclusion. Decide, yes, this falls within the Statute of Frauds, but it meets the part performance exception, so it is enforceable. Once you have your own ironclad conclusion, you become the measuring stick. You remove your hand, and you simply scan the 4 options to find the one that perfectly matches the conclusion you already reached.
Be your own measuring stick. I love that. Finally, the professor advises having a home run rule statement memorized and ready to deploy.
specifically for defining an offer, because almost every single contracts essay will require you to analyze whether an initial offer was valid. The memorized point-scoring definition is this. An offer is an objective manifestation of an intention to be legally bound, containing sufficient and definite terms and clearly communicated and identified to the offeree. You drop that exact verbatim sentence into your IRS structure, and the grader immediately knows you command the material.
Boom, maximal points. So let us synthesize this incredible sprawling journey we have been on today.
It really is a journey through the mechanics of human interaction and trust.
We started by figuring out which legal universe we were operating in, UCC or common law. We learned how to build a contract out of thin air using the alchemy of a bargain for exchange, and how the surrender of a legal liberty creates binding consideration. We decoded the sneaky, devastating traps of fine print using unconscionability and the reasonable expectations doctrine to shield the vulnerable. We dissected the messy reality of performance, figuring out whether a missed deadline was just a broken promise requiring damages or a fatal condition that blew up a 90-year monopoly. And we learned exactly how courts calculate the dollars you're owed and the rare instances where they force you to hand over a unique customized textbook when someone breaks their word.
And we gave you the architectural blueprint, the IRS structure, the mnemonics, the measuring stick, to translate that knowledge into a top-tier law school exam.
But I wanted to leave you, the listener, with a final thought, pulling back from the stress of the exam room and looking at how this entire framework applies to your actual life. Throughout this deep dive, hovering behind every single case we discussed, is a unifying philosophy known as the objective theory of contracts.
It is the bedrock principle of modern commercial law.
Exactly. The law fundamentally does not care about your secret internal intentions. It does not care what you meant to say in your head. It does not care if you were joking or distracted or confused. We are bound exclusively by our outward manifestations, what we say out loud, what we write down on paper, and how we physically act. If your outward actions look like an agreement to a reasonable outside observer, the law says you agreed. You are bound.
It's a sobering, slightly terrifying thought when you realize how casually we bind ourselves every day.
So I challenge you to think about your own daily agreements as you walk through the world this week. Are your outward actions truly reflecting the deals you think you're making? The next time you're online and you impatiently click I agree on a massive 40-page terms of service pop-up window without reading a single word so you can download a new app.
Remember the burglar who picked the lock?
Remember the farmer who lost his entire insurance claim to a bizarre definition hidden in 6-point font. Remember the devastating cross-collateralization clause that cost a single mother everything she owned. And ask yourself, what is your reasonable expectation? Because in the cold, objective eyes of the law, that casual click of your mouse is your definitive manifestation of intent.
It definitely makes you want to read the fine print twice.
It changes how you view every transaction. Thank you for joining us on this deep dive. Keep questioning the fine print, keep looking for the bargain for exchange in every deal, and we will see you next time.